We are starting now. Today is a 230th Friday group meeting. The topic is parties to litigation. The speaker is Mr. V.Prabhakar, Senior Advocate. He recently designated as Senior Advocate by this Honorable Court. He is kind enough to give on this very important topic and subject. Now I request Soumya Sharma will give a small CV of sir.
It is our honor to introduce Senior Advocate Mr. V.Prabhakar, a esteemed member of legal fraternity. With spanning over 4 decades, Mr. Prabhakar has established himself as a leading authority in civil law. Admitted to the bar in 1981. From 1981 to 1998, Sir practiced in Civil Court, Chennai, Honorable High Court of Madras. From 1998 till date, Sir is practicing in Honorable Supreme Court of India, Honorable High Court, National Consumer Dispute Redressal Commission, New Delhi. His impressive track record comprises numerous cases and significant contribution to shaping the legal landscape. As sought after counsel, Mr. Prabhakar advises and represents clients across various sectors such as civil law, service law, criminal law, taxation law and arbitration. Renowned for his commitment to justice and in-depth knowledge of law, Mr. Prabhakar is respected mentor and thought leader contributing to various legal publications and conferences. Sir was designated as Senior Advocate by Honorable Supreme Court of India on 19th January 2024. Friday group facilitated him on 19th February 2024. Please join us in welcoming Senior Advocate Mr. V.Prabhakar.
Sir, now I will initiate.
Not be required, I think my voice is fairly low. Good afternoon, brothers and sisters. The topic today is parties to litigation. While brooding over this subject, I found that it's fairly vast and huge, and probably a short time may not be sufficient to cover all the topics under which this heading would fall. So I have decided to confine myself today to those provisions in the Civil Procedure Code only. And even in that, I find that each of the provisions require a lot of discussion and something to be said on them. So I was telling Mr. Rao that today I will just give a brief outline of those provisions of the Civil Procedure Code which deal with parties to litigation. And if need be, we will have another sitting on specifics of the provisions of the code. We can then split it up so that we will have more time and we will have a better understanding of the subject. You are all aware that the code consists of two parts. One is the section, the other one is the orders and rules. The code as defined in the Civil Procedure Code, that is section 2(1), says it includes the rules. Now rules has been defined as under section 218 to mean the first schedule. First schedule consists of the orders and the rules thereunder. Apart from this, there are other provisions which empowers the High Court to frame rules. That is section 122. The High Court could regulate or frame rules in respect of those of the civil courts under its jurisdiction. It will not be applicable to other courts which are not falling within the jurisdiction of the concerned High Court. Another provision is also there under section 125 which says that the courts can, that is other than the High Court, I'm talking about other than the High Court, can frame its own rules. Now, of course, that is subject to the conditions which this concerned state government may lay down. Now, broadly, this being the scope of the civil procedure, I'll have to now go into what is a plaint. All of you all know that plaint and written statement form part of the pleadings under Order 6, Rule 1. A plaint has to be filed in a court which has jurisdiction under Section 26. That's what the section says. Order 7, Rule 1 speaks about plaint. And while doing so, it says, I'm confining myself only to the parties. I'm not going into the other aspects which the plaint should contain. While doing so, Order 7, Rule 1 says that we must give the party's name, description and address of the parties. Now, it includes not only that of the plaintiff, but also that of the defendant. So, all the details of the litigating parties have to be set forth in the plaint. This probably is to enable the court to issue summons to the parties or call upon them whenever required, so that the court is having a notice of the address of the parties. The plaint can be of two varied things. One could be, a plaint could be filed in a representative capacity, or it could be in an individual capacity. I'll come to the individual capacity later. Now, when a plaint is filed in a representative capacity, the persons who sue, that is two or more persons who join and file a suit in a representative capacity, they must first show that they have an interest in the subject matter and they have done all things that will enable them to file the suit. That is, they call themselves representatives of the rest of the people who are not before the court. Similarly, a suit can be laid against the defendants also in a representative capacity. It is not as if it's only the plaintiffs who can sue, it is also the defendants who can file a suit in a representative capacity. Apart from the suit being filed in a representative capacity, a suit can be filed by a group of persons who have an interest in the subject matter and who claim the same relief. That is, one or more persons can join. It may not be a representative suit, but it could be a suit filed by individuals who have the same interest in the subject matter and who are claiming the same relief as against vis-a-vis the defendants. That is provided under Order 7, Rule 4. Now, similarly, as far as the defendants are concerned, they can also be sued in a representative capacity, and when such a suit is filed, the defendants should be such, those who are impleaded should be such that they represent the whole lot of the defendants who will answer any decree that may be passed, because that becomes binding on the rest of them who are not before court. When suits are filed by, as I told you, you can file a suit by joining few plaintiffs. Similarly, defendants also could be joined, but again the condition being that they should have an interest in the subject matter and they should be able to be capable of answering the decree that is to be passed. It should be arising out of the same transaction and the relief claim should be one and the same. That's how when various individuals join and file a suit. Like for example, a partition suit. The brothers could join together, file a partition suit. The defendants could be the sisters, mother, father, and the rest of them. So in that event, it is not called a representative capacity suit, but a suit filed by individuals claiming their respective rights. But the subject matter is the same, that is the partition, and the relief claimed is a division in the property. In that event, they can all be one together, to be filed together. Now, this purpose of probably permitting different persons to join together to file a suit, or to make the defendants to join together and resist a suit, is probably to avoid multiplicity of proceedings. Otherwise, each individual has to file against each of the defendants, and this will lead to a lot of litigation blocking the procedure in the courts. So probably this is the object seems to be to avoid multiplicity. A plaintiff in a suit is the dominus litis. He has to decide as to who are the parties he wants to sue and against whom he wants to sue. He cannot be dictated that you implead X, implead Y. He cannot be. He can choose and say, I don't want X and Y, I want only Z. So as a dominus litis, he has got the right to decide as to whom he is going to sue, and the court will have to go on that. The exception is there, I'll come to that a little later. There is an exception. The court can direct a particular party to be impleaded. So that provision is slightly different. I'll come to that later. Now, when a suit is filed in a representative capacity, a permission of the court is necessary. In the absence of a permission of the court, the suit cannot be numbered and proceeded with. The court has to weigh whether the persons who are seeking that permission do represent a group or larger group of persons whose interest is common, and these people can deliver or protect their interest either as defendants or as plaintiffs. So it is the court will then decide and grant permission, and only if the permission is granted, the suit will get numbered and then placed for further proceedings. Now, when a suit is filed in a representative capacity, the plaintiffs cannot suddenly say we are withdrawing, abandoning the suit. Because it's filed in a representative capacity, the interest of the others who are not before court would get affected by a withdrawal of the suit or abandoning the suit or not prosecuting diligently. In that event, the court has the power to direct publication of the pendency of the suit in the newspapers, and call upon those who are interested in the subject matter to come before it for the purpose of prosecuting the suit. So that power is vested in the court, because after filing a suit in a representative capacity, for the purpose with ulterior motives, if some suit is filed and they withdraw the suit, then the bar of filing another suit will arise. So to avoid that, the power is given to the court, so that the court protects the interest of those whose interest would otherwise be affected or would have to be safeguarded. These are all provisions you will find under Order 1, Rule 8 of the Civil Procedure Code. The next important provision insofar as parties are concerned is Order 1, Rule 10. Order 1, Rule 10 is 10.1 is a provision where the suit has been laid in the name of a wrong person or a wrong plaintiff. In that event, the court can direct that name be corrected or substituted so as to enable the court to proceed further with the suit. Order 1 Rule 10.1 is one where the suit has been laid in the name of a wrong person. Order 1 Rule 10.2 is a provision. Now, while I am at that Order 1 Rule 10.1, wrong person, a similar provision, an application can be filed under Order 5 Rule 2.3 of the Supreme Court rules to strike off a party. So there is a provision in the Supreme Court rules also that when a wrong person has been sued or then in that event you can make an application before the Supreme Court and it will come before the court and he will decide whether to strike out or not. Order 1 Rule 10.2 is a power vested in the court to strike out. I told you the plaintiff is the dominus litis, he decides whom he has to sue. But this provision, Order 1 Rule 10.2, enables the court to strike out or add parties. Where a person has not been properly joined or improperly joined, then the court can say strike him. Where a person who ought to have been made a party, made a defendant, but has not been made a defendant, then the court can say make him a party. Now under this provision, two things flow. One is the person who is impleaded should be a necessary party to the suit. And apart from being necessary party to the suit, there is one other category of persons who can be impleaded in the suit. They are proper parties. So there are two categories of parties who can be sued in a civil proceedings. One is necessary party, the other one is, along with the necessary party, proper party. A necessary party is one in whose absence the suit cannot be decided or adjudicated upon. He must be present in the court, he must be a party to the proceedings for the court to pass a decree or dismiss a suit. So he becomes a necessary party. But a proper party is one against whom no relief need be sought for. But his presence will be necessary for the court to enable the court to give a proper adjudication. It may be that the interest of a proper party may be remotely affected. It may be. But the relief claim may not be against him, would not be against him. It will be only against the necessary party that relief will be claimed. A proper party is therefore, his presence is necessary for the court to adjudicate the dispute between the plaintiff and the necessary party. Now, similar to Order 1 Rule 10.2, that is the striking off, there is a provision in, as I told you, in our rules, Order 5, Rule 2.3 of the Supreme Court rules. Now, the distinction between a proper and necessary party is that a proper party is impleaded to facilitate the court to decide that suit. Whereas a necessary party is one without whom the suit cannot be proceeded with or decided. There is a distinction. One is to facilitate the court to proceed. The other one is necessary for the court to proceed. Without this necessary party, the court cannot pass any orders or decree. Whereas, even if a proper party is not before court, the court can pass a decree. The words used in Order 1 Rule 10.2 are any person who ought to be joined. Who ought to be joined refers to a necessary party. And The words whose presence before the court is necessary refers to a proper party under Order 1, Rule 10.2. Now, having seen that this is a broad aspect in which the plaint has to be filed and who are the parties to the suit, the plaintiff. Now, there are certain provisions which require certain parties to be specific under the Civil Procedure Code. One of the provisions would be in a suit filed by the plaintiff, the defendant is entitled to take a counterclaim or plead set-off. In that event, the counterclaim or the plea of set-off that is claimed by the defendant in the suit would be treated as a plaint by itself. In that event, the plaintiff in the suit would be treated as the defendant in the set-off or counterclaim of the defendant. And he will have the same, he will have to file a written statement insofar as the set-off or counterclaim is concerned, as in Order 8. A suit filed by, say, X for a certain relief, in that the defendant pleads set-off or counterclaim. The person who had filed the suit says, I am withdrawing the suit. Then what happens to the counterclaim? The Civil Procedure Code says that it will be continued, and it will be continued as a suit by itself. That is, a set-off or counterclaim will be taken up and decided, even though the main suit under which the counterclaim came in has been dismissed for default or non-prosecution over. Or even if it is tried on merits, the court will decide the suit on its merits as well as the counterclaim and pass a decree accordingly. This is with regard to a normal suit between plaintiffs and defendants. Now, there are instances where a defendant may plead that he is liable to be indemnified by a third party to the proceedings in respect of the claim raised by the plaintiff. The plaintiff is suing the defendant for a particular claim. The defendant in that suit may plead that I am entitled to be indemnified by a third party who is not a party to the suit. And in that event, the defendant will make an application before the court, and the court on that application will issue notice to the third party, who is not a party up to now. The court will issue a notice to the third party. And once the third party receives the notice, once the summons are served on him, he becomes a party to the suit. The court will then decide, inter se between the defendants, the liability. Apart from the liability of these defendants vis-a-vis the plaintiff. So this is not a party originally in the suit who is brought in by virtue of a claim made by the defendant that he is entitled to be indemnified. A third party is brought in and he also becomes a party to the suit. So this is a provision which brings in a third party into a proceedings where the plaintiff as such is not claiming relief against him, but a defendant is claiming a relief against his co-defendant. It's called a third party procedure, and the notice that is issued is called third party notice. This falls under Order 8, capital A. Apart from these general provisions, we have under the Civil Procedure Code certain orders which speaks about certain specifics. Like, for example, order (27), which is a suit by or against governments. Now, when it comes to a suit by or against governments, a reference has to be made to section 79 of the Civil Procedure Code. Section 79 speaks about if it is a suit against a union, against the central government, then the union has to be made a party. If it is a suit against a state, confirmed, then the state has to be made a party. So when it's against the government, generally under Article 27, then you will have to see whom you are suing, whether you are suing the central government or the state government, and accordingly you will have to implead as defendant the concerned state or the union. Of course, the government, central government again, or the state government is also entitled to lay suits, in which event they decide, because if it is a central government, the union will file the suit. If it is a state government, the state will file the suit. There are also suits, Civil Procedure Code prescribes suits in respect of defense personnel. Now, if a suit is laid against a defense personnel and he is in the border, he cannot immediately resist the suit and take part in the proceedings. In that event, there is a special provision made under the Civil Procedure Code which permits such defense personnel to authorize someone else to resist the suit on his behalf. Now, the person who is so authorized can himself appear in person based on that authority or engage a counsel. So, this is not a party in person as such. It is an authorization by a defense personnel because he is unable to attend the court, authorizing some certain person to defend his case. That is provided under Order 28 of the Civil Procedure Code. Now we have seen corporations, we have seen governments, we have seen defense personnel. Then there are suits filed by or against corporations. When we sue against corporations, we cannot name the corporation as such. The corporation has to be represented by certain people. And that is set forth in Order 29. That is, it has, the suit has, if it is a suit filed by the corporation, it has to be verified by the secretary of the corporation or the director or the principal officer who is aware of the facts of the case. So no Tom, Dick and Harry can represent the corporation and file a suit. It is only certain people who have been given the authority under the code to file a suit. Similarly, if they are made a defendant, corporation represented by either the secretary or the principal officer or the director of the corporation has to be sued. So there is a representation for the corporation by a proper person who will have the knowledge of the facts of the case. Then we have suits by or against partnership firms. That is covered by Order 30 of the Civil Procedure Code. Now, when we talk about partnership firms, automatically the first thing that comes into our mind is whether a partnership firm can be sued or can sue or be sued. It cannot be unless it is registered as contemplated under Section 69 of the Partnership Act. So I am proceeding on the basis that it is a registered partnership, and on that basis, if a firm is to be sued, the partner can sue on behalf of the firm, and the matter is, details thereof is given under Order 30 of the Civil Procedure Code. Now, there can be suits by trust and trustees. This is covered by Order 31, where the properties are vested in the trustee, executor or administrator, and where the contention is between the persons beneficially interested in the trust and a third party, then the trustee or the executor or administrator of the trust can lay a suit or resist a suit. In such suits, it is not necessary that all those who are interested in the subject matter have to be implicated. Only those who are really resisting need be brought out. Then we have suits relating to mortgages. In suits relating to mortgages, which is covered under Order 34, in suits relating to mortgages, the principal parties are the mortgagor and the mortgagee. But there may be instances where there could be a sub-mortgage also. In that event, mortgagor, mortgagee and the sub-mortgagee. In suits relating to mortgages, it could also possibly be that the mortgagee has sub-mortgaged the property. In that event, the suit could be confined only to the sub-mortgagee and the mortgagee, and the mortgagor need not be made a party there. A suit for redemption, insofar as the sub-mortgage is concerned, it could be as between the two who are parties to that transaction, and the mortgagor as such need not be made a party. Though, in such a suit, the mortgagor would be the mortgagee himself, vis-a-vis the sub-mortgagee is concerned. So, these three people are the most essential people in a suit for mortgages. Then we have what is an interpleader suit. An interpleader suit is where several persons make a claim in respect of a same transaction or debt or thing. And the plaintiff is not able to find out as to whom he has to actually pay or satisfy insofar as the dispute is concerned. Number of persons are claiming a right. The plaintiff is not able to decide to whom he has to pay and satisfy the debt. In that event, he can file an interpleader suit where the plaintiff's interest is just to lay the matter before the court. And it is for the court to then decide, as between the defendants, who would be entitled to the relief or not. That is why we call it as interpleader suit. The plaintiff will be only entitled to the cost as such. If you look at the provision, it is only the cost which he can claim. And it is for the court to decide, vis-a-vis the defendants, who would be entitled to what, whether proportionately or entirely or otherwise. This is a peculiar suit. Very, very rarely do they come up, but then this is also a form of a suit that is available under the civil procedure. Similarly, there's another interesting provision in the Civil Procedure Code under Order 36. 36 is a suit where two persons can make an agreement regarding a particular dispute between them. and then place that and then place that agreement before the court and call upon the court to decide the rights of the parties in that. Suppose there is a dispute with regard to a particular division of a property, how it should be divided, what is the proportion. We enter into an agreement. The parties enter into an agreement and ask the court, please decide as between us how it should be resolved. The peculiarity of this provision is, as against this, if a decision is given by the court prohibits a further appeal. There is no further appeal provided. So probably rarely resorted to by litigants because the further hierarchy is not available to them. Otherwise, this is a very good provision. In fact, a thought came to me that normally when we lay suits, there is an exchange of notices between the parties. Now, while exchanging the notices, the difference between the parties comes to light, at least insofar as the lawyers who have given the notice are concerned. They understand that this is the area of dispute between the parties. While thinking aloud, I am just thinking aloud, in that event, the lawyers could sit around with the parties, make them enter into an agreement, and ask them to approach the court for a decision and resolve the matter once and for all. Instead of waiting for the hierarchy of courts up to the Supreme Court to decide the matter. Probably this is a subject where we should give a little more thought and see if it can be made more workable amongst the litigants. This is a thought which I am thinking aloud. Maybe a lot of deliberations will have to be gone into, and this will resolve a lot of will avoid wastage of court's time, starting from the trial court up to the Supreme Court. In fact, we see in the Supreme Court, why don't you settle, go to mediation. This we can do it in the initial stage and resolve it. Instead of waiting after 40 years when the third generation of litigants are before the court. This is a thought which probably we will have a discussion at a later point of time. Then that was Order 36, and for that the provision is Section 90 of the civil procedure. The equivalent provision which is given is Section 90. Then the other important one is suits by or against minors. This is a thing which we come across on a day-to-day basis, where we either have to file suits on behalf of minors or against minors. When a suit is to be instituted or filed against a minor, the plaint must contain a statement regarding that. In the absence of a plaint containing such a statement, the plaint is defective. That you will find under Order 7, Rule 1D of the civil procedure. A statement will have to be made that the suit is against or in favor, by on behalf of a minor. When a suit is laid on behalf of a minor, the minor cannot be made a plaintiff directly. His name will be there, but he will have to be represented by a person called next friend. In the absence of a next friend, again, the suit is not tenable. Just the name minor will not suffice. If his name is given, his name has to be followed by a person who is called a next friend. Now, in such a suit, most often an application is made along with the plaint, to permit a person to sue as the next friend of the minor. And the court, considering the capacity of the person who is seeking such a position, his interest in the suit, etc., will grant the permission. When such a permission is granted, the suit will be proceeded by the minor, represented by the guardian, next friend, and once such permission is granted, it will hold good till such time the minor attains majority or the guardian seeks discharge, retires, or dies. So, a suit instituted in the trial court on behalf of the minor may come up to the Supreme Court, where he could still remain a minor, which rarely happens because of the number of years we consume from the trial court till we come to the Supreme Court. But it might happen. In that event, no further permission is required. That person can sue. Now, this provision, as far as minors are concerned, is applicable to people who are disabled due to unsound mind, etc. The same provisions apply. The represented by a next friend is a must. Without them, it cannot be proceeded with. Now, having set forth the various suits that can be filed under the Civil Procedure Code, there's one other category which does not fall under orders under the first schedule. There's one other suit that can be filed. That is a suit in respect of under section 92 of the Civil Procedure Code. This is not governed by any order. When a suit is filed under section 92 in respect of trust claiming certain release which are enumerated in 92, then two or more persons or the Advocate General of concern can lay the suit. When two or more persons lay the suit, then again leave of the court has to be obtained. Only after leave is granted, the suit will get numbered and can be proceeded. So this is a special category of suit which falls in respect of trust matters. Now, in suits, the nomenclature given to the person who sues is a plaintiff, and the person against whom the suit has been laid is the defendant. Insofar as appeals and second appeals are concerned, they are called appellants, respondents. If it is a revision, petitioner, respondent. So these are the normal nomenclatures which we use. But there is one special category of name which we very often use, and more so in Supreme Court. They are pro forma. Now, what is this pro forma? Is a question. Pro forma party is one who has a lesser interest than that of a proper person. Okay. He is a person at times may be interested in the outcome, but has not participated in the proceedings in the courts below, or has remained ex parte. In that event, when we implead them here, we show them as pro forma because they have not participated. A pro forma party may be affected by the result ultimately that may come. Say in a suit for partition, a mother is sued. Mother is made a pro forma party. She does not contest the case because children are fighting. She keeps quiet. But anyway, when shares are determined, she also gets her rightful share. But she does not file any written statement or appear before the court to take any sides of any of the children. She keeps quiet. Matter comes to Supreme Court. She remained ex parte in the trial court, the appeal, maybe even the second appeal if the value of the suit is such that a second appeal will lie. Then the Supreme Court. In that event, she is made a pro forma party. She may be affected by the outcome. The Supreme Court may vary the shares for whatever reasons, or may find that she is not entitled to any share. In that case, she may be affected. But however, we use them as pro forma. So a pro forma party is a person who has a lesser interest in certain circumstances, maybe a person who has an interest, maybe a person who would be affected by the decision, ultimate decision, but however has chosen not to participate in the proceedings, and therefore we term them as pro forma party to the suit, to the proceedings. Apart from this, we have a special category insofar as the Supreme Court is concerned. The special category is an intervener. He is not a party at all to the proceedings. Right from the trial court, he has never been made party under any capacity. But he finds that his interest would be affected if he does not poke his nose into the litigation. Therefore, an application. In fact, in the earlier rules of the Supreme Court, before the 2013 rules, an intervener was not permitted to address the court. That was the provision. That has been since amended, and under the present rules, an intervener can address the court. That is Order 5, Rule 2.3, and also Order 17, Rule 3. Order 17, Rule 3, as it stood earlier, did not permit an intervener to address the court, whereas the present order permits. He is entitled to the entire paper book and also address the court. This is the gamut of the parties insofar as civil litigation is concerned. And I have confined it only to the Civil Procedure Code and our Supreme Court rules. Now, each of these topics or headings require a further in-depth discussion because each of them has its own intricacies and debatable questions may arise in those proceedings. Like, for example, I was telling an agreement between parties. Then what is the difference between the one provided in the Civil Procedure Code and the Arbitration Act? That is also an agreement between the parties to refer to someone. These are larger questions which would arise once we start going in depth into each of them. Similarly, like for example, an interpleader suit. There may be various questions that could be thrown up. So I think we should have those specific topics for a discussion on a different group meeting than going into specifics. Here again, I have not touched upon decisions of the courts, because there are varied decisions. I have not touched upon cases where parties die. What is the position? Who is to be impeded? Because that is again a different topic in itself. Legal representatives bringing on record within time, out of time, beyond time. That is, out of time I mean proceedings abating. Then if abatement is not set aside, then it becomes beyond time, attracting Section 5 of the Limitation Act. So that those topics I'm reserving, we'll have a discussion on a different date. I would only thank all of you all for having given me a patient hearing. I don't know how, whether my enlightened you all or not, I'm not very sure. But thank you very much.
Thank you very much, sir. Prabhakar sir, the way parties to the litigation you justified 100%. Plaintiff, respondent, different forums, central government, suits and various these things are greatly analyzed. We are the fundamentals actually for every
Here's the
lawyer.
fundamental.
Fundamentals. It requires for from trial court to civil court to Supreme Court also. Very nicely explained. See how much crowd and very patiently they hear. It's a quite learning process in fact. For conscious citizens also, not only for lawyers, for conscious citizens also. Now I request Geetanjali Sharma will give vote of thanks. Each minute 10,000 cost.
Very good afternoon, everyone. Absolute pleasure for me to be offering word of thanks to Mr. V.Prabhakar, Senior Advocate, on behalf of all of Friday Group. It sets stronger the foundation, the more stable the building. Amidst all the IPRs and cyber laws, learning and discussing a fundamental like parties to litigation, sir, was so energizing and refreshing. Sir explained how in a suit the plaintiff is the dominus litis. Sir also talked about an interesting interplay of CPC in Order 1 Rule 10.1 and the Supreme Court rules when it comes to a wrong party person having been made a party. Today's lecture also elucidated about the concept of third party notice. Individual parties to state parties to defense personnel to corporations to trusts, interpleader suits to interveners before the Supreme Court. Sir threw light on all aspects of in less than an hour. Sir, we are very thankful for this beautiful and meaningful lecture. Thanks to all the members of the Friday Group and everyone present here for helping today's lecture to be what it is. Last but not the least, a very warm and heartfelt thanks to the administrator of the Friday Group, Mr. G.Seshagiri Rao sir, for tirelessly bearing the flag of knowledge called the Friday Group. Thank you, everyone.
Thank you, Geetanjali. So nice of you. Nice words for me also. Sir, we will continue in part 2. We will fix it.
Yeah, we will decide, we'll
Yeah.
segregate this into,
November or
we'll
somewhere
split
around.
it up.
Yeah, split it.
Because the whole